Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle.
Lovely good afternoon to you all out there. It's another Saturday, and we are excited to come your way live on BWTV with the community and the law. As a family member of an EU national, will the period to settlement be extended to 10 years under the new rules that have been proposed? We shall be delving into this. Our resource person and guest is a partner of BWF Solicitors, lawyer Eunice Echampon. My name is Oreku Frimpong. Let's get into this together. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422780. It's the community and the law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, 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 lovely people. Thank you so very much for making time for us to meet and discuss things that bother us when it comes to legal matters. My name is Oreku Frimpong, and I welcome you to this afternoon's edition of the Community and the Law. This afternoon, we're going to look at a very interesting topic. You know, back in well, a few days ago, I should say, we had several things are changing when it comes to the long stay, getting to your indefinite leave to remain situation, and the rest of it. As a family member of an EU national, are we going to have the period to settlement extended to 10 years? We're asking that question, and we're going to have that answer because we have, fortunately, partner of BWF Solicitors, lawyer Eunice Acheampong, here with us this afternoon to help us do that. So first of all, let me do the rightful thing and welcome lawyer Eunice Acheampong to the show. Lawyer, good afternoon.
Good afternoon, Kweku. How are you doing?
I'm good. How are you?
By God's grace, I'm doing well.
Good, and I know the family is quite good as well.
Yes, by God's grace, they are doing well. They're on half term this week, so they've been enjoying themselves, enjoying the sun, and worrying me as well.
Well, it's family time, so we cannot say, well, because sometimes you see when they go to school, they come back quite late, you come back quite late, and
Yeah,
they go early the following day. So sometimes we miss them. So when we have the half time, let's enjoy it.
it's true.
Anyway, thank you. And we're grateful to all of them because they allow you at least some
Yeah.
2 hours every Saturday afternoon for you to be with us to help us with the build up of our knowledge. So thank you very much and welcome to the show.
Thank you so much as well.
All right. So, folks, if you have just joined us, I've introduced our resource person and guest, and we do this courtesy. BWF Solicitors are trusted partners when it comes to the law. BWF Solicitors help us with our immigration matters, they help us with our family matters, they help us with our marriages, divorce situations, and how we can link all those situations to our immigration statuses. And also, when it comes to business development and advice, you can trust BWF Solicitors to help you out. BWF Solicitors is on the fourth floor of the Anna House. That's 214 to 218 Tottenham High Road, Seven Sisters, North London, N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And you can call them, book an appointment, come see any of the lawyers and the caseworkers. They will so welcome you. And people have had that opportunity of enjoying the services they provide, enjoying the successes they help you achieve, and the rest of it. You can call them on 0208 493 7340, 0208 493 7340. If you are in Ghana, they have an office in Ghana that serves the Ghanaian community over there. 055 589 5959. 055 589 5959. In emergency situations, just call 0044 77 12 76 1884. 0044 77 12 76 1884. BWF Solicitors, we say they are trusted partners when it comes to them. And by their courtesy, we're doing the community and the law, and it's brought to you live on BWTV, at BWTV on Facebook and YouTube, and at BWF Solicitors on YouTube and Facebook. So if you just joined us, I know you do the rightful thing. When you enter the house, we welcome you. Normally, when you go to people's houses, you just take your footwear off and you walk with your socks onto the carpet, and we welcome you, we'll give you water to drink. So announce yourself. So those of you who are on our platform want to say welcome and thank you for being here. So as usual, as the tradition is, just let us know you are in here. Leave your comments in the comment section down below. And when we activate the phone lines, you can call in on 0208 493 7345. I will keep announcing that number whilst the program is ongoing. And I also want you to, if you can, send us a text or WhatsApp on 07399 208 468. 07399 208 468. That is our contact number and, of course, our text and WhatsApp numbers. So you can join the program when we give you the permission to do so. So thank you so very much. Let's delve into it and look at what we are going to really look at as far as our updates are concerned. But first of all, Shaibu is grateful, and he says that he wholeheartedly recommend BWF solicitors to anyone in need of expert legal representation. Their professionalism, integrity, and commitment to achieving the best for their clients are truly commendable. Thank you, Eunice and BWF Solicitors, for your outstanding service and dedication. And I know this, obviously, and most likely, will bring a smile on the face of Lawyer Eunice.
Yes, I I dealt well with Mr. Shebu Al Hassan. He is one of our clients, or should I say previous clients, and he was in tatters literally because he was thinking there's nothing that could be done in regards to his case, and with all cases, you need evidence, and when you don't have sufficient evidence, the next thing is it's likely to be refused. And he was looking to have the worst of the decisions, and God being so good, obviously, we're able to look into the law and then try as much as possible to apply the law to his circumstances. And he was so, so grateful when the decision came that he has been granted indefinite leave to remain. And so, on behalf of BWF solicitors, we also say congratulations, Mr. Shaibu Al Hassan, and we know that you will definitely be using us once again, and we look forward to your recommendations as well.
I know, and I can feel from some of the words that he has used in the review. I wholeheartedly, that shows the level of satisfaction that he has had. And describing the attributes of BWF solicitors, professionalism, integrity, and commitment to achieving the best for clients, that's truly commendable. I believe that people who have not tasted the success levels of BWF solicitors will take a cue from this one and contact them. The numbers are 0208 493 And as I said, the office in Ghana is also open for clients in Ghana to avail themselves to the services. 0233 55589 In emergency situations, as I've said, you can contact BWF solicitors on 004477 Or you can send an email to BWF solicitors admin at bwfsolicitors.com. Or visit the social media platforms, leave the direct messages there. YouTube, WhatsApp, Facebook, TikTok, what have you. So BWF solicitors, yes, we thank you and we're grateful. We will continue to use you for as long as you continue to do what you do for us. We're grateful. Anyway, the things they do for us, they help us enhance our knowledge and increase the amount of what we have in our repertoire. And one of the things and the updates they give us is by way of the nuggets that it's released every Monday between the hours of 9 and midday, and it continues with us. We bring it up on the program, and we look at a situation or a scenario that goes with this particular one. And you can find it on your screen. And the Civil Procedure Rules, that is CPR. You can make a claim online for a specified amount of money of less than £100,000, excluding interest or cost. The claim may be started on His Majesty's Courts and Tribunals Money Claim Online platform, where the defendant has failed to acknowledge service of or defend the claim. The claimant may seek a default judgment. However, if the defendant didn't have a fair chance to respond, they may ask the court to set aside the judgment and be given the opportunity to defend the claim. This one is quoted from the CPR Rules 1.1, subsection 1, 1.2a, 12, and 13. That is Denton and White case of 2013, England and Wales Court of Appeals case. That is Decadent Vapors Limited versus Bevan and others. A bit technical, but I know once we have Laura Eunice here, we have the haven to even go to get some explanation. So please, can you help us with this one?
Yes. So this is generally looking at civil litigation cases where there are timelines that have been set by, for instance, the court, and the civil procedure rules are a set of rules that have been set by the court that both parties that are coming to court will have to comply with. And so, if you are either the claimant or the defendant, you have to look to the CPR rules to be able to meet certain timelines. And as the nugget states, well, the claimant has made a claim. The defendant says, well, I didn't have a copy of the claim, therefore, maybe I should be able to set aside the judgment that the court made in favor of the claimant. And so CPR 12 talks about default judgment, and the court has the power to make a default judgment where the other party has not put forward any other claim or defended the claimant's claim. And then CPR 13 talks about the court setting aside the default judgment because for one reason or the other, a rule may not have been complied with. And so in the case of Denton and White, and so you see that there are cases that have been listed as part of the nugget, and it's three cases in one basically. So all these three companies were involved in one matter, and this was a court of appeal case, and all three parties, should I say, did not comply with the CPR rules. And so there were deadlines to when they could obviously send the court certain documents, and they were not able to meet those timelines. And so they had to go back to the court to ask for the court to basically give them relief for their sanctions. So they haven't complied, but they were asking the court for a relief. And in two of those cases, the court decided to set aside the trial date and then scheduled another date for the trial. But the case set out three-stage test to be complied with when making a decision for the claimant to have relief for sanctions. So if they haven't complied with one of the CPR rules and they are looking to the court to obviously give them a relief, this is what the court is saying they will go by. And it's a three-stage test. And the first part of the test has to look at the seriousness and the significance of the breach by the claimant or the party that is seeking for relief. And then the second part of the test has to do with the court looking at whether the party has a good reason for the breach that they have made. And then the third part of the test has to do with the court looking at the case in the round. So they look at all the circumstances of that case so that they are able to act justly and fairly in the proceedings. And CPR 1.1 and 1.2 look at the court's, should I say, objective, which is to act justly and fairly in all cases. And so, because in two of those cases, the judge had to set aside the trial date for another hearing date, they said that the breach was serious enough, and therefore it meant that the parties will not be granted relief for their non-compliance of the CPR rules. And so it's important to know that if for one reason or the other the rules have not been complied with, or the other party is able to prove that certain rules were not complied with, the court may go ahead and set aside a judgment that was previously made in favor of the claimant or the person who is applying to the court for a relief. And so that is in a nutshell what the nugget is all about.
Well, let me ask this, and the first part says somebody or you can make a claim online for a specified amount of money, less than £100,000, excluding interest or cost. So let's say, for instance, I've sued somebody and I'm making a claim that they should pay me damages of amount less than £100,000.
Yes.
Do I necessarily need to go to court, or as this one says, I can go online and make that claim for the judge to pick up and to make a ruling on? Do I have to appear in court for these things?
So yes, we would say you would definitely need to appear in court. So the first part of the nugget is referring to how the claim should be made. So if the claimant is saying that he is owed 100,000 or less, they can make the application online. And so we thank God that due to COVID, a lot of things are now done online. So yes, you can make the application to the court online, and the court will then process this and will require you to come for a hearing once they have some form of availability. If, of course, your claim is more than £100,000, then it will be better to make a paper application to the court, and then they can process it that way.
All right. Well, that's what the nugget is. If you need further explanation, you need some clarifications, you can contact BWF Solicitors 0208 493 7340. 0208 493 7340. Emergency situations, as I keep saying, 077 127 61884. It's not the community and the law. Now, having said this, let me see. I have this scenario, and I would want you to help me answer that. We will come back to it at the tail end of the program, but look at this for me. Slybule issued a 15,500 claim, including interest and costs, against Innocent Simpleton via the HMCTS money claim online. The court sent the claim forms to Innocent's last known address, but he had moved 6 months earlier. Unaware of the claim, Innocent didn't respond. 30 days later, with no response from Innocent, Sly obtained a default judgment. I would want to take that situation again. Think about it carefully. Slybule issued a 15,500 claim, including interest and cost, against Innocent Simpleton via the HMCTS money claim online. The court subsequently sent the claim forms to Innocent. They knew of the last address, so they sent it to that address. But unfortunately, he had moved 6 months earlier. So obviously, Innocent Simpleton would claim that, well, I didn't know. It didn't come to meet me. So he didn't respond. 30 days later, with no response from our said Innocent, Sly obtained a default judgment. So what I'm asking is, what should Innocent do now? The person that the claim was served on, who had moved from the known address 6 months earlier, and 30 days later, so virtually after 7 months, he says that, well, I wasn't aware. So what can he do? A, pay Sly 15,500 immediately to avoid a CCJ or county court judgment. That's what it means. Or set up a payment plan to stop bailiffs from visiting his property. Or could it be that we could advise him to apply to the court to set aside the judgment and defend the claim? Look at these three scenarios. Give me the correct one. But just oppose that to the nugget that we had earlier on, where we explained that under civil procedure rule, you can make a claim online for a specified amount of money, less than 100,000, excluding interest or cost. And we also said in the third paragraph, where the defendant had failed to acknowledge service or defend the claimant may seek a default judgment. However, if the defendant didn't have a fair chance to respond, they may ask the court to set aside the judgment and be given the opportunity to defend the claim. Think about that. I'll be looking at that at the tail end of the program. So in the meantime, thank you so very much for sticking around. We're going to take a quick break. And when we come back, we will delve into our discussion. And the question we're asking is, as a family member of an EU national, will the period to settlement be extended to 10 years? Yes, no, maybe so, I don't know. We'll come back to answer that. It's still the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. I know you are making your presence felt on the platform in the comment section below. Share the page, allow people to also enjoy what you are enjoying, because we have a pool of knowledge we have delved into, and we're all going to benefit from that. I mentioned earlier on that this afternoon we're going to have a discussion on the topic extending the 10-year, your route to indefinite to 10 years. We have different categories. We have those under immigration rules and those under EU settlement scheme. So as a family member of an EU national, we're asking, will the period to settlement be extended to 10 years? Big question, a blunt one, but I know we can unpack them and get you to understand what really the situation is. Laura Eunice, would it be extended to 10 years?
No. This is an honest and a genuine question that somebody put to me. And so it meant that a lot of people just heard the settlement period will be extended to 10 years, and they are all over the place. So I think it's proper and right for us to look at the white paper that the government introduced, and even though it's not law as yet, they have given us an idea as to which category of people this would be applicable to. And so we want to put people's mind right so that they don't think in such a broad manner.
Okay. So then let's look at which category is going to be affected. I'm asking that because that is where the confusion probably has started from. That the white paper says that people's route to indefinite is not going to be the standard 5 years when you have stayed on a particular route, or the 10-year route when you have stayed for various circumstances and reasons. It's going to extend to 10 years. I know people who are on the skilled worker route have that big concern because they think that things are going to change. Who is affected by the proposal in the white paper?
Okay, so when we look at the white paper that the government introduced earlier on this month, they have stated categorically that they are going to be looking at um, the routes to settlement. And if you look closely at page 68 to 69, it talks about the fact that those who are on the points based system
Mhm.
have the privilege of obviously extending their leave to a 5 year period. And then after that 5 year period, they will attain settlement. But it also makes statements regarding some of the fact that some of the migrants that have come into the UK as skilled workers may not necessarily integrate well in the UK culture and the UK society. And therefore, it is one of the reasons why they have decided they would rather move the settlement period from 5 years to 10 years to afford people the time to integrate well in British society. That is what has been stated in the white paper. And so it says categorically that those who are on the points based system, and we know that people on the points based system include those that are skilled workers, those that come in as students, those who have even come in through the what do you call it, innovator route, startup business, global talent route. Um, there are other work routes as well that I can't mention, but obviously when it comes to the points-based system route, there were quite a number of categories that this would involve. We know for the students that their leave does not lead to settlement. And so this will mainly deal with those who are on the work route, such as the skilled workers, the global talent innovator, founder route, the global talent route. Those are the main routes that would obviously lead up to settlement, and therefore these are the people that will mainly be affected by the government's proposal to extend the settlement period from 5 years to a further 10 years in terms of people now being well integrated and settling into the UK. And we all know that settlement is a prerequisite or a requirement needed when you are going to naturalize as a British citizen. When it comes to applying for naturalization, definitely you will need to show that you have acquired indefinite leave to remain in the UK for at least 12 months before making such an application for naturalization. And they have said that they are going to look at other should I say, criteria in regards to naturalization applications as well. But as of yet, they haven't stated when this will become law. A lot of people have been talking and saying, oh, does it affect those who are under the EU settlement route or under the family route? No, it is not applicable to those who are on the family routes. For instance, those receiving 2.5 on the 10 year route. You're already on the 10 year route, so this
Mhm.
is not applicable to you at all. Those who, for one reason or the other, may have lost their spouse while here in the UK as a partner of a British person or as a partner of somebody who is settled in the UK, this will not be applicable to them. And the government have said that they will even introduce a route for those children who have lost a father because of one reason or the other. Currently, the rules only apply to bereaved partners. So, having the bereaved child will also be a good one to add to those families that are looking to regularize their stay here in the UK. And also for those who have experienced domestic abuse in one way or the other,
Mhm.
they would still be able to also apply for settlement or indefinite leave to remain once they are able to provide evidence as to the domestic abuse that they have suffered whilst on that route, which is the partner route or the family route. So it's important to note that it is not applicable to all immigration categories, but specifically for those who are on the points based system.
Okay. So, having said that, I know the source of confusion again will be as to what the route is for people who are under the EU settlement scheme or EU nationals, the route to indefinite or settlement. Can you enlighten us as to what the route is? If I come in with as a dependent of a settled person, if I come in and I'm given pre-settled, what is the picture like from when I come in to the point where I could get my settlement? Just help us with that.
Yeah. So usually with anybody who is a family member of an EU national who has already acquired pre-settled status or settled status here in the UK, most EU nationals in the UK would have to make an application for family permit
Mhm,
for their family members to join them here in the UK. So if they can show that they were a family member before the specified date, which is the 31st of December 2020, they can apply under the EU settlement scheme for family permit to join the EU national who is living here in the UK. And so once they are granted family permit, and the family permit is usually valid for a 6 month period. So once the family member enters into the UK with that 6 month family permit, they would then have to make an application for pre settled status or limited leave to remain, usually within 3 months of entering into the UK. Most people usually do not make the application in time, but they have given a grace period of 3 months. And so, as long as you have made the application within 3 months of entering into the UK,
mhm,
you would have made a valid application. So once you've made an application for pre-settled or limited leave to remain, you would then have to provide evidence of your relationship. I know obviously once you were granted the family permit, you would have provided evidence of relationship prior to you being granted family permit. They would need that again in terms of this current application for pre-settled or for limited leave to remain. You provide evidence of relationship, and then depending on what application you are making, you will have to provide evidence of dependency or your should I say residence here in the UK. So if you've said you've lived in the UK for at least 3 months, you should have some sort of evidence that shows that you are indeed residing here in the UK. And it could be a letter from the shop, a letter from the GP, any piece of evidence, maybe a mobile phone statement. It could be anything which has the address you are living at. So once they are able to have evidence of your residence and evidence to show which category you are applying under,
mhm.
they are likely to grant you limited leave to remain here in the UK. If you are then applying for settled status or indefinite leave to remain, you must show that you have resided in the UK for a continuous period of 5 years. And therefore, once you are able to show that you have resided in the UK for a continuous period of 5 years with the EA national, those who are retained rights holders would usually have to prove that they've retained their rights.
Okay.
But those who are still family members of the EA national must show that they have resided here continuously for a 5 year period with the EA national. And that would mean you have to provide proof of address for each of the 5 years that you are relying on. And so if you are saying that you've resided here since 2020, then you have to provide evidence for 2020, 2021, 2022, 2023, 2024, 2025 in order to show that you have
Would,
indeed resided.
would a P60 be enough proof for this thing?
Well, they have access to your NI, so they will make their checks. So one of the things they request is your NI. Most of the time, what they really want to know is whether you are residing here with the EA National. And
Okay.
so even though the NI number might be able to prove maybe 4 years, and then maybe the first year in which you came, you may not have worked for, let's say, 6 months. So they might not be sure whether you were indeed here or not. So they might ask you for further evidence of your residence in the UK. In that case, you will still need to provide evidence for that particular year that they are requesting. And then most cases they will ask for evidence of the EA national if the EA national is also not working in the UK. So where the EA national is not working in the UK, they can't see from their NI number that they've been working. They will request for evidence that shows that the EA national has been residing here in the UK and you have been residing here with them. So it's very, very important that you show that both you and the EA national have resided, or you have both lived here for a continuous period of 5 years. And this goes out especially to those people who have received emails to say that the Home Office will automatically grant you settled status if they can assess from their system that you have reached the period of settlement. It's not all hunky dory, because I know people who may not have worked consistently and they haven't been granted settled status. So it is in your best interest to make that application if you can show by way of evidence that you have resided here for the past 5 years. The law does not say that you must show that you have worked for the past 5 years. It says you must show that you have continuously resided in the UK for a period of 5 years. And so if it has to do with residing here, then you can show evidence of your bank statements, or you can show evidence of letters through your GP or through the council, or bills that you may receive. And that will be sufficient evidence to show that you have resided here for the past 5 years. And usually they are looking at evidence of more than 6 months for each 12-month period to show that indeed you have resided in the UK. And so it's important that when it comes to settlement under the EU settlement scheme, you are able to provide enough evidence to be able to be granted indefinite leave to remain on that basis.
Be any situation at all where the 5 years would be extended to 10 years? We're not talking about the white paper, but in the normal circumstances, is it limited to 5 years? Or there could be situations where it could be extended up to 10 years.
Yes, so for instance, those who are on the family route, we have those who may have come as a family member. So, for instance, there are those who may have come as partners of British nationals or settled persons who are already here in the UK. And once you are able to meet certain requirements under Appendix FM, you are granted leave to remain on the family route for a 5 year period, because you have been able to meet all the requirements. Where all of the requirements are not met, you may be given leave to enter on the 10-year route because certain requirements were not necessarily met. And so leave will be granted outside of the immigration rules. And you also have those who are family members who are applying within the UK. And so most people who are making applications within the UK as family members of British nationals or settled persons, whether it's a partner or a child, they too will be granted leave to remain on the 10-year route because certain requirements have not been met, especially those who are making applications because, first of all, they were overstayers or for one reason or the other, they have found themselves wanting and they haven't regularized their stay in the UK. And now they have a British child or a child who is settled or a child who has lived in the UK for a continuous period of 7 years. So, because they are making the application on the basis of that child who is seen to be a qualifying child, they would therefore be put on the 10-year route because they cannot meet the immigration status requirement, or they cannot meet the financial requirement, or they cannot meet the English language requirement. But the mandatory requirement which they must meet is the relationship they have with that child or the relationship they have with their partner in order for the application to be processed.
Could there also be a situation where um, somebody under the EU scheme or a member of the EU national, a family member, would be refused to attain settlement status? Could anybody be denied?
So usually when it comes to those who are EU national family members, if for any reason your application is refused, whether it's in regards to the fact that you don't have enough evidence to show that you have lived there continuously for a 5 year period. And
Mhm.
let's also remember that there are suitability requirements. And so when I say suitability requirements, that means that there are requirements that may not come under the eligibility requirements, but the Home Office is looking to see whether the applicant has made any applications where they have made any false given any false information or any misrepresentation, or for one reason or the other they may have been convicted of a crime and they were sentenced to a year imprisonment or more, or for one reason or the other, they've been given an exclusion order, and so they are meant to be excluded from the UK. And so there are those suitability requirements which the Home Office also do not take lightly. And if you do not meet certain suitability requirements, your application may be refused as well. And so, in cases where, for instance, your application has been refused, yes, you may, of course, make an application further down the line if you do believe that, for instance, they're telling you, okay, your continuous residence requirement was not met. And so maybe you need 1 more year to be able to make an application for indefinite leave to remain when you have been able to accumulate continuous period of 5 years. Or it could be the case that there is no way that you are going to gather enough evidence to show that maybe the EU national is still residing here in the UK, and therefore you are making application on a retained right basis. So it might be the case that you have suffered in an abusive relationship with the EA national, and there's no way you can gain further evidence of her residence here in the UK. In that case, it will be better to obviously appeal and then make your claim to the court that since your relationship ended, the EU national has left the matrimonial home or has left the home that you lived in together, and there is no way by which you would be able to provide any documentation on her part whatsoever, on or on his part whatsoever, and you may be able to provide evidence of the abuse that has gone on. Usually, most people may have things recorded to their GP. So maybe your GP has records of you coming to make complaints of headaches, or maybe they've taken tests to find out that you have high blood pressure or you have depression, or there has been occasions where you have actually gone to the police to report an incident due to what was happening in your home. And so in those cases, it will be better to appeal and then have the court, which is a third party educator, to look into the evidence that you have, so that they can make a decision based on what you have provided, and then further grant you leave if for any reason or the other you may not have been able to convince the Home Office otherwise. Those who usually apply on a retained right basis, if your leave is granted to you, you will be granted uh, pre-settled status or limited leave to remain if you have not been in the UK for a continuous period of 5 years. So, where you have not been in the UK for a continuous period of 5 years, it is less likely that they would grant you settlement on a retained rights basis. But if it's on the basis that you were abused, or if it's on the basis that for one reason or the other, the party that you are referring to has passed away, they will grant you settlement straight away.
Well, if you just joined us, we are live on the Community in the Law, brought to you by BWF Solicitors. We're live on Facebook at BWF Solicitors and on YouTube at BWF Solicitors. BWTV at BWTV on Facebook, BWTV on YouTube. As a family member of an EU national, we're asking, would the period to settlement be extended to 10 years? I know the question has come a lot during the week. People are asking, with a white paper published, the government's intention made clear, is that going to affect people who are family members of EU nationals? Lawyer Eunice Champon, partner of BWF Solicitors, has categorically said no. We have delved into some of the things that we need to know. We will be looking at what the situations could be and how you can navigate some of these things. It's the Community and the Law, stick and stay. But before then, let me say thank you to William Champo Akolo, Sandra Fraser, Helena Kimi. You're saying good afternoon, Bra Frimpong, and Lawyer Eunice. We appreciate your dedication and support for the community. God bless you all richly. Thank you, Helena. Thank you very much. Jima Boache, God bless you, Bra Kweku. Thank you, Jima. God bless you too. We have a very terrible picture when you join. That's really, really important to us. Ubeida Yusuf, good afternoon, lawyer. Good afternoon, Ubeida. How are you as well? Nanaya, hello everyone. Hello to you, Nanaya, with an emoji of a heart. We'll have you back. Then we also have a lot of other people watching with us. Rebecca Mwako, thank you. Helena, you're there. I've mentioned you. Willie Champo, I've mentioned you. Efia Papebi, Nelly Kakari, and we have Augustina Champo, Maxwell Kwekubefi, you are with us. Daniel Vanderpoy, and of course, Jimabuachi, who sent us the message earlier on. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back and thank you for sticking around. We appreciate your presence. I know most of you are sharing, liking the page, and inviting people to join us. As a community on the law and our resource person and guest, by courtesy of BWF Solicitors, is a partner of the company lawyer Eunice Achampo. We're discussing the situation where people are kind of confused and thinking that the government white paper is going to affect EU nationals. So we asked the question as a family member of an EU national, would the period to settlement be changed to 10 years? Emphatically, it's no, it's not going to affect you. Laura Eunice has explained and giving us the assurance it's not. But we'll look at situations, and as I think I specifically asked the question whether in any situation the period could be extended to 10 years, whatever the conditions are. Laura Eunice has answered all that. The lines will be active from now, 0208 493 7345. 0208 493 7345. You can send a text and or WhatsApp to 07399 208 468. 07399 208 468. Laura Eunice, I'm asking the question again. Maybe somebody just joined us. The period to settlement for EU nationals, would it be extended to 10 years?
So I would like our producer to help us with the white paper, and then we can look at what has been mentioned by the government, and then see if at any point in time this will be applicable to EU nationals. So this is a government white paper. It says restoring control over the immigration system, and it was introduced earlier this month of May 2025. So today is the 31st of May. If we go down to page 68, this is to do with settlement. Yes, so earned settlement. Under page 68, it talks about the fact that the settlement in the UK is a prerequisite to becoming British citizen, and it brings a lifelong benefit, or it brings lifelong benefits. And so settlement is also an important step in integrating and contributing to local communities and the wider country. And so it talks about the number of people who have attained settlement since 2024. And it goes on further to explain those people who have attained settlement and their family members who have also attained settlement. So let's go down to page 69, please. It talks about the long-standing principle that settlement in the UK is a privilege. So it is a privilege and it is not a right. And so under the current system, settlement is primarily qualified for on the basis of length of time spent in the UK alongside a knowledge of the life test which is used to verify knowledge of British customs, history, traditions, laws, and political system. So, as part of any naturalization application and currently settlement application, you would also have to take the Life in the UK test, which will test your knowledge on British history, traditions, laws, and political systems and customs. And so it says in 263, paragraph 263, that these criteria alone do not reflect our strongly held belief and that people should contribute to the economy and society before gaining settled status in our country. And if they fail to promote integration, which limits the wider benefit from long term migration into the UK and increases pressure on public services, we will therefore reform the current rules around settlement through an expansion of the principle behind the points based system that individuals should earn their right to privileged immigration status in the UK through the long term contribution they bring to our country. And it states under paragraph 264 this expansion of the point based system will increase the standard qualifying period for settlement to 10 years. We will continue to offer a shorter pathway to settlement for non UK dependents of British citizens to 5 years, provided they have remained compliant with their requirements, and we will retain existing safeguards to protect the vulnerable, including settlement rights for victims of domestic abuse and violence. And so, through the expansion of the points based system, individuals will also have the opportunity to reduce the qualifying period based on points based system contributions to the UK economy and society. And we will consult on these changes later this year. So,
If you may,
yes,
I have a question on 265. In fact,
okay,
265 uh, vis-a-vis 264 as well.
okay,
264 is saying that the expansion of the point-based system will increase the standard qualifying period for settlement to 10 years. And they
yes,
continue to say we will continue to offer a shorter pathway to settlement for non-UK dependents of British citizens to 5 years. Um,
yes,
can you clarify non-UK dependents of British citizens? So if
yes.
a person has EU status, for instance, um, then they have acquired a settlement to that bed. We're not talking about 10 years here. We're talking about just the 5 years.
Yes.
Or who are those non-UK dependents and British citizens? How they acquired the status? Would that be looked at before they consider 265, for instance?
Okay, so paragraph 264 is basically giving a broad view of the government's intention to increase the qualifying period of
Mhm.
extension for those on the point based system from what it is, which is currently 5 years, to 10 years.
10 years,
And
okay.
then when you go further to paragraph 265, it talks about um, giving a shorter pathway to settlement for those with non UK dependents of British nationals or British citizens. And we were talking about family members of British citizens or those that are settled in the UK. And family members usually mean those that are partners or children. And so, if I, as a parent of a British citizen, so let's say I have a child who is under 18 here in the UK, and unfortunately, the child's father, who is here in the UK, has passed away, but the child hasn't got anyone to look after them. I make an application to join my child here in the UK. If I'm able to show that I meet all of the requirements, which includes the relationship requirement, the English language requirement, and the financial requirement, then I will be able to apply and I'll be granted leave on the 5 year route. Or if, for instance, I am the wife of a British citizen here in the UK and I make an application to join my husband who is here in the UK, if we are able to show that we meet the relationship requirement, we meet the financial requirement, we meet the English language requirement, and of course, I have suitable accommodation which I will be coming to live in, then they would grant me leave to remain on the 5 year route. I will continue to remain on the 5 year route for as long as I can meet the requirements, which is the shorter pathway to settlement than those who are on the 10 year route. And so this is mainly applicable to those that have come either as a spouse or as a parent of a British citizen and have met all of the requirements and therefore have been given leave or have been granted leave on the 5 year route instead of the 10 year route. In my explanation before, I was saying that most people who have made an application within the UK may not be able to meet the immigration status requirement at the beginning, and therefore they will be put on the 10 year route because they cannot meet one or all of the other requirements apart from the relationship requirement. So, yes, that is paragraph 265 explained in a nutshell.
Okay. Then it's quite interesting. Even though 266, for instance, the last sentence says we will consult on these changes later this year. But they're saying that through the expansion of the point-based system, individuals will also have the opportunity to reduce the qualifying period based on point-based contributions to the UK economy and society. They are taking it with the, or giving it to you with the left and taking it away with the right. Can we look
Yeah.
at it that way? Because it's like they are giving you an escape route that is 10 years, but you can have a way of reducing it to 5.
Yes, so like I was explaining with the family route, obviously there are those who can meet all of the requirements and have it shortened to the 5 year route, and there are those who cannot meet certain requirements and so will remain on the 10 year route. So I believe that they will need to do proper consultation because it is not very clear as to what they mean to put certain people on the reduced 5 year route and then put certain people on the 10 year route. So it will be interesting to see what they come up with after their consultations. And most of the time, the MIIR, which is the Migration and Advisory Group within Parliament, they are the ones that usually advise the government in terms of immigration matters. So it'll be interesting to see what they come up with after their consultation to then make a bold decision as to those who qualify under the 5 year route and those who qualify under the 10 year route.
Well, wait and see. Definitely, when they have done their consultation, they will definitely give us the information. And when we have any questions, our dear lawyers will be on hand to help us with the explanation. We're live on BWTV, and we're bringing you the community and the law brought to you by kind sponsorship of BWF Solicitors, our trusted partners when it comes to the law. I've said that you can visit them, send any questions to them. If you need consultation on how to make applications, how to appeal against decisions, and the rest of it, talk to BWF Solicitor 0208 493 7340. 0208 493 7340. Or emergency situation 077 127 61884. If you want to speak to Lawyer Eunice directly, you also have the opportunity to speak to her. Number will be on the screen in a moment. 075 3581 3910. Lawyer Eunice 075 3581 3910. At this point, the lines are active. You can call in 0208 493 7345, or you can send a text to WhatsApp and text number 07399 208 468, or you can leave your questions and comments in the comment section down below. But remember, I have the scenario I have given you based on the nugget that we gave you earlier on, and I would want you to look at it again and think about it, because I'll be asking you to give me the answers. Under civil procedure rules, you can make a claim online for a specified amount of money of less than £100,000, excluding interest or cost. The claim may be started on His Majesty's Courts and Tribunals, that is HMCT's money claim online platform, where the defendant has failed to acknowledge service of or defend the claim. The claimant may seek a default judgment. However, if the defendant didn't have a fair chance to respond, they may ask the court to set aside the judgment and be given the opportunity to defend the claim. This one, as lawyer explained earlier on, several cases put together, CPR rules 1.1, subsection 1, 1.2a, 12 and 13, and the case Denton versus White 2013, England and Wales Court of Appeal case, Decadent Vapors Limited, and Bevan and others were also contesting. Then I asked you about my friend Sly Bullet, who issued a £15,500 claim, including interest and costs, against Innocent Simpleton via the HMCTS money claim online. The court sent the claim forms to Innocent's last known address, but he had moved 6 months earlier. Unaware of the claim, Innocent obviously didn't respond. 30 days later, with no response from Innocent, Sly obtained a default judgment. So what should Innocent do now? Should he pay Sly £15,500 immediately to avoid a county court judgment? Should Sly set up a payment plan to stop bailiffs from visiting his property? Or we would advise Sly to apply to the court to set aside the judgment and defend the claim. Think about these ones. But I think we can have you call onto the line and come in with the questions put to Lawyer Eunice Acheampong, or you can put that in the comment section down below. Now let's get on with it. Stephen Jenso Kupo says, please, if I join the army now, will my indefinitely remain count from when I first came to the UK in 2021 and switched to a skilled worker visa in 2022, or it starts as I joined? Lawyer.
Okay, so in terms of the army, what I know about settlements in the army is you should have been able to have lived here for a period of 5 years as well. And so usually for the army, those in the army, their requirements and the way they are granted leave is also separate from most categories under the immigration rules. And so once they've resided and they've been in the army for that 5 year period, they can gain settlement. Obviously, he may not be in the army for that period of time, and so he's thinking, do I have to count from the time I came into the UK in 2021 and then switched in 2022? When it comes to counting your previous leaves, that would mean that for one reason or the other, maybe you may not have been able to attain settlement in your current category in which you are in. And therefore, you have to be able to add up the other categories as well, because the army is so strict. It relies on just that period in which you have been in the army. So if for one reason or the other, let's say um, you were not able to gain settlement within the army and you left the army, and now you've gained family root settlement, what do you call it, leave to remain under the family roots category, then it means that you are counting towards a 10-year settlement period. And so, if you are going to count your leave from the time that you entered up until the 10 years that you are on your family route, then that's fine, fair enough. But for those who are specifically on the army route, it will only be you acquiring the qualifying period within the army that will lead to your settlement.
Well, thank you very much, lawyer. Yes, we're picking your questions, we're picking your concerns. We are asking the questions on your behalf. What's the best route to settlement for someone on a skilled worker visa, lawyer?
So very similar to those who are in the army, if you're on the skilled worker route, your route to qualifying as a settled person will have to show that you've been here for a qualifying period of 5 years. And so if for instance you were on the skilled worker route and then for one reason or the other you were able to gain an endorsement, and so you were shifted onto the innovator founder route for self sponsorship, for instance, they will count your period of being on the skilled worker route with that of being on the innovator founder route as part of your 5 years qualifying period to settlement. And so when it comes to those on the skilled work route, all work routes are usually seen as one, and therefore you can count that towards your 5 years continuous residence to settlement. Yes, I mean, you can decide to be on the skilled worker route to gain your settlement. You can combine other work routes to gain your settlement. So it doesn't necessarily matter. The only thing is that if you were on the skilled work route and then you switch to, let's say, a family route, then it means that you are counting your time towards a 10-year qualifying period rather than a 5-year qualifying period. So, and that is something that most people should have to bear in mind.
I think one of the things that probably we will have to be hammering on would be the difference between the 5 year route and the 10-year route. Oftentimes, people get them kind of mixed up and confused.
Hmm.
Um, so, with time, we may have
Yes,
to do probably a full program on that to
yes.
get people to know why people are on 5 year route, why people are on 10-year route,
Yeah.
and people thinking of, can I switch from the 10-year route over to the 5 year route? Which category of applicants and people do these situations affect? 5 year or 10 year? We may have to come to that. But still, we're looking at your questions and your concerns. Bring them in. You can send a text, as I said, 0739920848, or you can call in 0208 493 7345. British Report is asking, lawyer, how long does it usually take to process a spouse visa or a skilled worker visa? Uh, it looks like they are two scenarios here. But then
Yes.
I would ask it in another way. A spouse visa on, or depending on if somebody who's on a skilled worker route.
Yes, I think it's best to put it in those two different ways to answer it. When it comes to those who are on the spouse or partner visa route, the Home Office have categorically said that it will take them about 8 weeks to process the application. But we always let clients bear in mind that there can be extenuating circumstances on the part of the Home Office as well, and so it's best to bear in mind that at least they have a 6 month leeway or a 6 month period in which they can process the application. So Those who are on the spouse or the partner route, usually it's 8 weeks to process the application. And then when it's those on the skilled worker route, so those who are dependent on the skilled worker, usually they also give that same time frame of 8 weeks. But we always tell clients to bear in mind that framework of 6 months, because sometimes you may not get a decision within 8 weeks, and then you're thinking, oh, why have they taken so long? They usually send emails when they are processing these applications to let you know the time frame by which they would process these applications by. So whether you're a dependent on a British citizen or a dependent on a skilled worker, usually the processing time is about 8 weeks. But if it does go beyond, of course, they have that leeway to extend their deadline to making a decision. And in that sense, you will be able to get an email from them to say that they are going to take a bit longer than necessary to respond to your application.
Keep them coming through. Thank you, lawyer. 0208493740. We have somebody on the line. So let's see to pick up that person. Hello.
Hello, lawyer. Good evening.
Good evening, my dear.
All right. Thank you so much for the good work you are doing.
Thank you for sticking with us and trusting us as well.
Yes.
Well, lawyer is ready for you.
All right. Please, I'm on a skilled worker visa and I'm the main applicant.
Mm-hmm.
My contract was signed for 3 years, and I've been here 2 years and some months. My visa is going to expire in November. Sorry, my employer's license was actually revoked for about a year, and she asked us that she's taking the issue to court, and that if you want to leave and get a switch, yes, you can. Almost everyone has left. Just a few of us are still with her because of her money issues. I haven't been able to get a switch. Fortunately, this month she has been reinstated. So I saw that on the app, on the Home Office website, her license has been given back to her. I alerted her. I asked her about it. And then she said to me that, yes, she has been reinstated, but she is not going to renew it for me. I asked her why, because I'm still working with her. She still gives me hours to do. I work from Monday to Friday, and I haven't switched yet. I'm still working with her. She tells me that she will give me a reason why she cannot renew the 2 years, the remaining 2 years for me. And it's been close to a month now. She hasn't.
But do you still have your hours as she gives you?
Yes. Somewhere along the line, everything went down. She didn't have enough. We're doing 3.5 hours, 4 hours. Currently, I do 5 hours, 6 hours, sometimes 4.5 hours. But she's telling me that my visa is going to expire in November and she will not renew for me, even though her license has been reinstated and given back to her. But she will not renew for me. Now, last year, she denied us of having our annual leave or holidays. The reason being that she said she was not going to pay. So if you try to go on holidays, of course, she will allow you to go and she will not pay you. She actually did not pay me. I went for 1 week. She never paid me. So I was forced to come back to work because I cannot stay home with no salary.
Okay, so what is your question? You asking lawyer what you could do?
Yes, I'm asking lawyer what I can do about her denying me of my holidays the whole of last year. And again, now that she's telling me that she cannot renew my visa for me, and my visa is due to expire in November, I have not been able to get
So let me also help and ask this question. How long was your contract for? Your initial
Please, it
contract,
was
how long was it
it
for
was
you?
for 3 years, please.
For 3 years. And the three
Yes, it's
years
going.
the 3 years end in November this year. Is that what you are saying?
Yes, please. Yes, please.
And she says that she's not going to renew for you.
Yes, yes, yes.
Okay, hold on and let's get a response from Laura.
Okay, I think on the first issue of her holiday, this is a separate issue to her COS. So it's an employment issue actually, because every employee is entitled to at least 28. I mean, that's they say 20 days and then 8 days bank holidays. So if 20 days and then 8 days bank holiday, then that's 28 days. So if she is defaulting on giving her employees holiday, then obviously she will be breaching some contractual terms in terms of contracts between her and the employer. That would be a separate employment issue. So obviously she would need to think very hard whether she wants to go down that route of making a claim to the employment tribunal in that regard. On the second issue of renewing the COS, employers are usually not under any obligation whatsoever to renew an employee's COS for them or extend their leave in any way. Yes, for now she's been reinstated. I don't even know whether she's still got a grade A rating or the rating has been reduced because of previous revocation of the license. So, depending on the rating that she may be given, obviously she may not be able to renew your COS for you. And on the basis that she has categorically told you that she's not going to renew your COS, I think it would be better to find another employer who would be willing to provide you with an extension of your leave by providing you a new COS. So, in this scenario, unfortunately, because there isn't any obligation on the employer, yes, the government have issued new immigration rules to say that those employers who are looking for international workers or who are looking for migrants to work in their company should first look for them within the UK rather than going outside. They do not necessarily have to extend your employment contract if they do not wish to do so. So, unfortunately, there is nothing that can force your employer to also take you back on, but it will be advisable to look for another employer who would be willing to give you an extension to your leave here in the UK.
Thank you very much, lawyer. I
You're,
appreciate it.
you're welcome.
You're most welcome. Thank you very much. The lines are still active 0208-493-7345. Or, as I said, and as we have been doing, you can leave them in the comment section down below on Facebook at BWF Solicitors, YouTube at BWF Solicitors. Let's pick another one from the platform before we move on to any other of the platforms. Amelia is asking, lawyer, what legal options exist for reuniting with family members if my visa is refused? I'm assuming it's a family visa you are talking about here.
Yes, it's very vague, but let's try and look at the categories under which her visa may be refused. So I'm assuming she's here in the UK. I'm also assuming that she may have made an application um for a family member, whether it's a parent or a partner, I'm not sure. But if she's making an application under Appendix FM, which is family route for those who are family members to those who are British or settled, and let's say the application is refused. What can she do when it comes to family applications that are refused? It could be refused maybe because she doesn't meet the requirements, and usually if the mandatory requirement, which is the relationship requirement, has not been met, they are likely to refuse the application, especially if it's just a spousal visa application, and you are saying to them that you are in a genuine and subsisting relationship. Of course, if they have any suspicion that it may not be a genuine relationship, they can refuse the application. Or maybe you have proved that you are in a genuine and a subsisting relationship, but you are not able to show that you meet any of the exceptions to the immigration rules. So maybe you don't meet the immigration status requirement, you don't meet the financial status, I mean, the financial requirement and the English language requirement, and you're refused. The immigration rules allow for you to show that maybe there is a child who is here in the UK that you are responsible for, and the child may be British or settled, and it will be unreasonable for that child to leave the UK. If there is no child as such as that, then the next leg they look to, or the next limp, will be to say that there are insurmountable obstacles to you and your partner leaving the UK. So if you have not been able to give clear and convincing arguments that unfortunately you and your husband cannot go back to the country where you are from to make the application, or there are no insurmountable obstacles, then the application will be refused, and it means you will be offered a right to appeal. And so I would suggest that you use that right of appeal if you believe that there are still grounds for you to make that claim. Then of course you can go ahead, because it's very vague. So this is just an answer that I'm giving based on my assumptions.
Well, if you send in anything, try to be clear and concise. And of course, let us know exactly what you are trying to ask for. Whilst the answer is given, you can give us further details of that, and the lawyer will do well to help you. Grace Mensah is asking, lawyer, how long would it take for the Home Office to issue a switch visa when it's applied for?
Okay, so depending on which category you are switching to, if it's on the family route, usually they say 8 to 12 months. So 8 weeks to 12 months. So if you're on the partner route, then usually it's 8 weeks. If you're on the parent route, usually 12 months. If you are switching to, let's say, a skilled worker route, it's the same 8 week period. And so, depending on the route you are switching to, there are different processing times.
Okay. Well, keep them coming through. Let's pick up another one here. But remember, I'll be going back to my question and the scenario I gave you. So keep them coming through. Well, Grace is saying skilled visa.
Okay,
I
so
think
she's
she's
making
come
a
to
switch
clarify.
from a skilled worker visa to another skilled worker. So, yes, it will still be that same 8 week period. Yes.
Okay. 8 week period. Think of that and work within that. Sometimes, Laura, when it goes in and it hasn't come out,
Yeah.
obviously, people panic.
Yes. Yes. And they will send an email to that effect to let you know if they will take longer to make a decision. Yes.
Okay. All right. Next one. Let's see what else we have. It's a similar one. Ajani Mbwate, what should I do if my home office application has been delayed for months? Do I make noise?
When it comes to home office applications being delayed, yes, you can always make a complaint. They have a complaint web form on their website. They also have a complaints email, which is complaints@homeoffice.gov.uk. You can also send a pre-action protocol, which is what we as legal representatives do. We usually send a pre-action protocol, and they usually come back with a response as quickly as possible. And in most cases, if you've tried both complaints and PAP and still for months there's no response, then we say go ahead and report it to your Minister of Parliament, and they should get a response as soon as possible as well.
Yes. So yeah, obviously, speak out, and you will be heard. Grace Mensah is saying thank you very much. Yes, Gracie, thank you as well. I hope that your question is answered, and if you need any further help, contact BWF Solicitor 0208-493-7340. Bright is asking, Home Office have given us 60 days to look for a new company to switch for us, but still we have not got some. How can we do? Or I think what you want to say is, what can you
Yes,
do?
yes. I think this is something that is very common to a lot of skilled workers whose leave is being cancelled. And I would say for our previous caller, she was in a good position because even though her employer's license was revoked, she didn't have her leave cancelled. So that is one of those scenarios that you would wish you were in, where the home office will not cancel your leave even though the employer's license has been revoked. In this person's question, Mr. Bright, Abrefa's question, where you are only given 60 days to make a switch. Unfortunately, most people are unable to find a company who is willing to offer them a certificate of sponsorship within 60 days. And so, in that case, if you are not able to find an employer who is able to make that switch, it's almost as if you have no legs to stand on. Um, for some, there is hope because you can make an application on the family route. If, for instance, you've met somebody whilst in the UK and that person is British or that person is settled, you can make an application as a partner or as a spouse of that British national or that person who is settled here in the UK. If for one reason or the other, maybe you found somebody, you're not married, but you both had a child together and that person is a British national, that child will also be automatically British by way of the parents being settled or British in the UK. So you can also rely on that child in order to also make an application for leave to remain in the UK within that 60 days. It's very, very restrictive. Unless you have very a lot of money, I would say then you can make an application on the student visa route. If you have enough money to show that you'll be able to pay for the tuition fees and the maintenance here in the UK, then you can also make a switch onto the student visa route as well. It's There's a lot of question when it comes to those who can make a switch, but within 60 days you have to look and see which route is more favorable to you and what you can do within that short frame of time in order to make an application. As Kweku has also given my number out, obviously you can call after the program, or you can also call our office line from Monday to Friday so that we can better
Okay,
help.
so I think Bright was going to ask that question, and you have really answered it before he did. Yes, you can have lawyer's number. Let me give it to you again, Bright. It's 07535813910. Don't call her now, she's on there. Just wait until after the program and you
Yes.
can do that. Well, I think we can take just the very last one. But thank you very much. We can take one last one before we take a quick break and come back to our nugget and quiz question. Lydia Paul, what rights do migrants on work or study visas have if they lose their job or course?
So I know she's put it as what rights do they have? Um, when it comes to immigration and regularizing your stay in the UK, yes, as somebody who has come in as a student or as a skilled worker, you are hoping to continue living in the UK even after you've lost your job or you have, for one reason or the other, been kicked out of your course. When it comes to looking for an extension, it's always best. For instance, those who have been kicked off the course, if it's to do with yourself, if you did not comply with certain um, requirements, then I would say, of course, you cannot go down the student route because you have not been able to comply with certain conditions in regards to your leave to remain in the UK. If, however, like I responded to the previous caller, you have met somebody who is British and settled here in the UK and you want to make an application, you need to do so before your leave expires. If you're on the work route, as well as I responded to the previous caller, yes, you can make an application if for one reason or the other the employer hasn't got any work for you. Look to see if there are other employers who will offer you certificate of sponsorship, or you can switch to the family route if there's somebody who you've met and the person is either British or settled, you can switch onto that route. Or if you're a worker and you have enough money to switch to the student route as well, you can also do so. So yes, there are a number of categories available to you, those who are usually in that category of um, having lost their course membership or having lost out in their job. You are available to look at other options as well.
We're live on BWTV. I'm going to ask you to test your knowledge, take a break, and when I come back, I'll take the answers. This will offer Loyina some time to take a break. And when you have given the answers, she will tell us which one is correct. Sly Boulay issued a 15,500 claim, including interest and costs, against Innocent Simpleton via the HMCTS money claim online. The court sent the claim forms to Innocent last known address, but he had billed 6 months earlier. Unaware of the claim, Innocent didn't respond. 30 days later, with no response from Innocent, Sly obtained a default judgment. What should Innocent do now? Should he pay Sly 15,500 immediately to avoid a county court judgment? Should he set up a payment plan to stop bailiffs from visiting his property? Or should he apply to the court to set aside the judgment and then defend the claim? Send your answers down to the comment section down below. We'll be picking that and looking at which one is correct right after these messages. And we're back, and thank you for sticking around. So, what answer should we, what should Innocent do? That's what I mean to say. What should Innocent do? Pay Sly 15,500 immediately to avoid a CCJ, set up a payment plan to stop bailiffs from visiting his property, or apply to the court to set aside the judgment and defend the claim. Jessica starts with B. Set up a payment plan to stop bailiffs from visiting his property. Okay, well, let's see what else another person says. J. Patrick. Patrick thinks that it is C. Apply to the court to set aside the judgment and then defend the claim. Victor Ajay thinks is C as well. Apply to the court, set aside the judgment, and defend the claim. Maybe Obediako thinks is C as well. Make the application, ask the court to set aside the judgment, then he'll come to defend the claim. Is he going to say that he's not going to pay or what? Timothy Yabua, Timo says B, set up a payment plan to stop bailiffs from visiting his property. Should you have his peace of mind? Listen, I'll pay you in bits and pieces. Stop people from coming to my property to seize my stuff. Janet Dia thinks that Innocent should set up or should pay 15,500 immediately to avoid a CCJ. Joseph Aday says is B, set up a payment plan, stop babies from visiting his property. Kwame Anand also thinks is B, set up a payment plan. Okay, well, what else? Who else? Philomena Amwako, pay Sly £15,500 immediately to avoid a county court judgment. Stephen Nkrumah thinks that Innocent should apply to the court to set aside the judgment and then defend the claim. Jeffrey Setre thinks same, make an application to the court to set aside the judgment. Olivia Mensah thinks yes, Innocent should make an application to the court. Yes, Olive, thank you very much for that. And Ernest Jumo thinks is B, set up a payment plan to stop bailiffs from visiting his property. I'll take the very last one and I'll go over to lawyer to get the explanation and think which answer would be the right one and what Innocent definitely would have to do. Angela Kusi thinks is B, setting up a payment plan to stop bailiffs from visiting the property. Lawyer, yes, we've tried.
Yes, I think it's very interesting the number of people who say B, because I feel like they're putting themselves in their Mr. Slybury's shoes and they're thinking, do you know what? I'd rather pay in bids so that I don't get into any more trouble. And
Right.
then it's also good to see that there are those who are actually thinking about the question and have put C. I think it's good that it's just one person who put A. Maybe the person was thinking, do you know what? I don't want any issues whatsoever. So it means it's better to pay the full amount so that the court doesn't come after me. Maybe that was the person's perception in terms of answering A. But if we look at the question, we have Sly Bully who has asked the court for a default judgment because they didn't hear from innocent simpleton. And so the court went ahead to give a default judgment in favor of Sly Bully. But innocent says, I was unaware of the claim and therefore, what do I do? And the answer very correctly will be C. It says to apply to the court to set aside the judgment and defend the claim. So, under CPR or Civil Procedure Rules 13, the court has the power to set aside default judgment, and then the defendant, who is Mr. Innocent Simpleton, has to go ahead and defend the claim. If he is saying that he wasn't at the address which it was sent to for the past 6 months or 7 months, he has to prove that he was not at the known address and he was living elsewhere, or his address had changed to the current address which he is now at. Obviously, it is up to him to defend that claim, and we'll then know what the court will advise or order otherwise. And so, yes, well done to all.
If you say it should ask the court to set aside the judgment and defend the claim,
Yes.
defend it in what sense? Is he going to dispute how much the amount is or what?
So
The person says
usually,
you owe him, and you are
yeah,
saying you didn't get the notification.
the
So when
claim,
you are
yeah.
coming, are you saying I don't owe you, or you're looking for time to pay?
So usually, either that the person is trying to tell you, I don't owe you that amount of money, or even if I owe you that amount of money, I don't have that amount to give to you now. So maybe I might need to ask the court to help me grant an order where I pay in installments rather than paying it outright. And so it depends on what his defense will be. Mostly the defendant is always going to say, I don't owe you that amount of money. And most of the time that's what the defense is, that the amount is too astronomical, and therefore maybe this is the correct amount I owe you, and not this amount of 15,000 um
500.
500. Yeah.
Well, Sly and Innocent, over to you. But then I'm coming back to the desk of La Eunice Champon to tell us what it is that we discussed today. Yes, La.
Yes, so we were discussing whether, as an EU national family member or somebody who is under the EU settlement scheme, you would have your period of settlement extended to 10 years based on the government's announcement earlier on this month to extend the qualifying period to settlement for those under the points based system to 10 years. And we've thoroughly looked at the topic, and we've looked at the government's white paper, which categorically states that they will be looking at extending the period of qualifying uh, leave to remain, or those who are qualifying for indefinite leave to remain, to 10 years for those who are under the points based system. And so those who are family members to settled people, or those who have British citizenship here in the UK, can still rely on being on the 5 year route to settlement, as long as they meet all of the requirements necessary. And if you are an EU national, you also do not come under this category of people under the points based system, as those who have been granted leave on the EU settlement scheme do have leave for 5 years, and after a 5 year period qualify to apply for indefinite leave to remain or settled status here in the UK. And it is important to note that the extension which the government is looking to introduce as law is applicable to those under the points based system. And those are those who are usually under the skilled worker route, or under the innovator founder route, or the scale up business route, or even those who are religious workers, or people within the other sectors of the business or worker route. And so it's important that if you are on any of these work routes, this will be applicable to you. It's important to also note that if for any reason or the other you are on the EU settlement scheme route and your application is refused for one reason or the other, you will have a right of appeal, and it is best that you use your right of appeal in getting a response to resolving your matter or your issue. And so, yes, having looked at this question today, there is no increment of your settlement period if you are under the EU settlement scheme or under the family route, based on those who are family members of British nationals or those that are settled. This new announcement by the government is not applicable to you.
So, as Laura said from the beginning, the answer is categorically no. And if you need any further explanation, if you want some clarifications, if you have any issue that you want to really get addressed, you can call BWF Solicitors on 0208 493 7340. In Ghana, 055 589 5959. In emergency situations, 077 127 61884. Visit BWF Solicitors on all social media platforms and you will be attended to. It's been a very wonderful afternoon here on BWTV, and we've had our very own lawyer Eunice Champon helping us answer our topic for the or the question for the day. On behalf of viewers, clients, and listeners, I want to say thank you very much, Lawyer Eunice. Thank you very much, BWF solicitors, from Uncle Ben right down to the very last person in the organization. And to my production team, Shilakra Padmododu, and my indefatigable producer and director, Professor Ade. I want to say thank you for being here. We have another edition for you same time next week, so we expect you to invite people to come join us so we do it together. My name is Oreku Frimpong. Have a good evening.